Hello folks, welcome back to the Edupedia world, and I am Abhinay Gupta. So today again we will be continuing with the winding up of the companies, right? Referring to the Companies Act 1956. Okay, so what were we doing in the previous lecture? Yes, we were discussing about the creditors voluntary winding up, right with that? And yeah, we were left with just two last provision that relates to the dissolution and calling of the meeting by the liquidator, right? So those two provisions, those two last pending provisions will be covered in the lecture today, right? We'll explain it to you in detail. Please keep in touch with the lecture and hope you understand it, right? So I'll just take you briefly through what we covered in the last class, that was creditors voluntary winding up. So we discussed that they need to call separate meeting of the creditors and the members, right? As you have seen in the case of members voluntary winding up, we called the meeting of the members only, right? But that is not the same case in the creditors voluntary winding up. We cannot wind up the company by calling the meeting of the creditors only, right? So for that we'll have to call the meeting of the members and the creditors. And remember, the creditors meeting will be called or held post the meeting of the members, right? Then we have send a notice to the registrar. Yes, whenever the liquidator is appointed, you send a notice to the registrar, right? The company does it. Then you have the appoint the liquidator and the committee of inspection. Yes, now this is one point of difference in this that we have already seen, that in the case of members voluntary winding up, there's one specific thing that you find nowhere in creditors voluntary winding up, and that was the declaration of solvency given by the directors, right? Similarly, the committee of inspection is one thing that you will find only in creditors voluntary winding up and also in compulsory winding up, but not in members voluntary winding up, right? So again, the members, they appoint the liquidator. Do they? No. The members may nominate a liquidator, and the creditors will also nominate a liquidator. And if they nominate the same person, that person is automatically the liquidator, right? But what in the case of difference? Difference can be of two types. One, that the members, they nominate Mr. X, and creditors, they do not nominate anybody. So Mr. X is the liquidator. Members nominate nobody and creditors nominate Mr. X. So Mr. X is again the liquidator. Members nominate Mr. X and creditors nominate Mr. Y. In this scenario, Mr. Y would be the liquidator, right? But you have some people have been given the power to oppose. Who were they? They were the directors, members, or the creditors. They can oppose. They can say that no, we want the creditors that was appointed by the member to be replacing the liquidator appointed by the creditor, right? Or they can also say that we want both the liquidators working jointly, or we don't want any one of them, please send an official liquidator. Or if there is any fourth category that can be put in to this place, we have left an open provision for that, right? Then we had the cessation of the power of the board. Yes, we already know that when the liquidator comes into play, when the liquidator comes in to take charge of the office, the power of the board ceases, right? That comes to an end. Then we have creditors would have the power to fill up the vacancies in the office of liquidator. Yes, if there is a vacancy in the office of liquidator, the committee of inspection, they cannot fill in the vacancy. The members, they cannot fill in the vacancy. Why? Because who had appointed them? The creditors. So the creditors will be given the authority to fulfill the vacancy. That means to reappoint someone. Maybe not the same person, some other person, but the reappointment in the office of liquidator will be done by the creditors, right? But again, there is one situation. What if somebody had approached the court and an official liquidator was appointed, and that official liquidator vacates the office? In this situation, the creditors will not be allowed to nominate anybody or to elect anybody. The power to fill up that vacancy will be given to the court, right? Because as a thumb rule, who has appointed the person who had vacated the office will have the authority to appoint a new person in the same office. So if the creditors, they have appointed a liquidator, creditor will appoint the new liquidator. If the court had appointed that liquidator, the court will appoint the new liquidator. Thumb rule, right? Then at last we saw that they had to send a notice to the registrar and the ITO. Who? The liquidator. 30 days for both of them, the registrar as well as the income tax officer. Now we come to the point that we did not cover in the previous lecture, right? So now you will have to be a little more careful, because now we'll discuss those topics in detail. So far we had just been touching those topics that we have covered in the previous lecture already. Okay with that? So here we see that it is the duty of the liquidator to call a meeting when the winding up continues for more than 1 year. Now what do we mean by this? Why is this provision being given in the section? Look, try and understand, right? Consider your place, consider yourself to be either the member or the creditor of a company. The company which is being wound up, right? So one fine day you get a news that either the petition was filed in the court, that is a compulsory winding up, either the members, they have raised an issue, they have passed a resolution, that is the members voluntary winding up, or this is the third situation, the creditors voluntary winding up. So suppose in your situation, right, your company is being wound up voluntarily by the creditors. Okay, that means you are not solvent, you will not be able to pay off all the debt, but the committee of inspection will take charge. Okay, now one fine day you get to know that okay, the creditors have called for the winding up, and you are also one creditor, or you are the member of the company. You say okay, you go back home, you start your other businesses, whatever you want to do. Then 1 month passed by, 2 months passed by, 3 months, 6 months, 10 months, then 1 year passed by, and finally one day you realize, hey, it's been 1 year when the winding up procedure started, and I have heard nothing about it so far. Is the company dissolved already? Is the winding up proceedings going on? Is something happening over there or not? You are not aware of it, right? Because you think that okay, it's been 1 year, I should have heard about dissolution so far. If you are getting nothing or you don't have to contribute anything, you should have heard directly about the dissolution. Otherwise, if you are the contributory, the company will be calling you. Hey, look, this is the amount due from you. This is the call money due from you. Please pay. Right? If nothing of such sort is happening and 1 year passes by, don't you think you have the right to know what has happened in this 1 year? Yes, you have. You are the member. You have been a member of that company. The company is in the process of winding up. So you want to know whether everything is going well over there, whether everything is going fine, whether winding up procedure is still continuing. Right? So that was the rationale behind it. The section said, specifically section 508, right? It says that the liquidator will have to call the meeting of the members and the creditors, both of them, all the people who are interested with that company. When? In the situation if the winding up proceedings continue for more than a year. And in that situation, the liquidator calls the general meeting of all the members and a separate meeting of the creditors as well. And that meeting needs to be called within 3 months from the end of the year. Right? So 1 year has passed, now you have 3 months time. The liquidator has 3 months time to call the meeting of the members and the creditors. Right? And this is not only for the first year. If the liquidation continues for 1 more year now, that first year ended, there was a meeting called, you came, you attended the meeting, you know, okay, this is the progress. And agreeable that okay, the liquidator will take some time. No issues with that, you go back home. Again 1 year passes and you have heard nothing. You will again want to know, right, what has happened in this 1 year. So again, once the second year comes to an end, again the liquidator has 3 months time to call your meeting again and again inform you what is going on. And the similar process continues year after year, year after year, so far or so long as the winding up proceedings continue. And what will the liquidator do at that meeting? What will he convey? What will he communicate? What will he say? Basically what he will do is he will place an account of all his acts and all his dealings throughout the year. Whatever he has done, whomsoever he has made the payment, whatever assets he has sold, whatever dealings he has done, he will lay the account containing the details of all of it, right? And also the conduct of the entire winding up procedure during the previous year, right? And with respect to that proceeding of the winding up, he will also lay a statement, and the form and the content of the statement will be prescribed. So that there is nothing specifically said about it in the act, but it says that time to time it will be prescribed what has to be there in the form and in what contents are to be included in the statement that has to be issued by the liquidator. Right? So you got the point. The basic crux over here is that the liquidator, if he takes more than a year's time, then he has the duty to let the people know, to let the concerned people know, the members and the creditor, about what is going on, all what actions have been taking place, what dealings have been there, the proceedings are winding up, the position, the prediction, right? How much more time does he need? What is the estimate? All these things have to be conveyed to the people who are interested. And just for that function, this is the medium. The meeting is the medium via which you will get to know the information about it. Because now the company is not working, right? So you are not holding any meetings. The members are not coming for holding any meetings. The creditors are not coming. They are not charging any claim because they know they will get the money on the basis of the priority, right? And that will be given by the liquidator. So you don't have to issue a notice every time. So none of you are interested in the company. None of you are connected to the company now. Hence, the liquidator will have to connect you via that meeting and then inform as to what is going on. Right? Then, now suppose meeting after meeting over, and third year or fourth year down the line, the liquidator says that yes, today the winding up proceeding comes to an end. Why? Either because you have been able to wind up the entire company very well, all the debts, all the liabilities have been paid off, all the assets have been sold, if there was any surplus that has been given back to all the contributories. Nothing is there with the hands of the liquidator or with the company. Or the other situation is that okay, now onwards the winding up proceeding cannot be carried forward. Why? Because either we have been exhausted with all the assets, we don't have any more assets to dispose, we don't have any more money, and hence we will not be able to satisfy the claim of the creditors or the liability holders. And if we are not able to do that, and we know that there is no way out, so what do? Over, the winding up proceeding is done. We cannot go further with any other proceedings, so it's time to dissolve the company. Right? So in both these situations, after the winding up is over, after the journey has been completed, you reach the destination. After the procedures have been done, you reach the event, and that event is dissolution. And we know that the dissolution can only be processed with by the order of the court. Right? Only the court has the authority to dissolve the company. No one else. Not the members, not the creditors, not the registrar, not the liquidator, nobody. Right? So what do you have to do? Once your proceedings are over, once the liquidator is done, the liquidator will have to approach the court. Okay, court, listen, all the proceedings are done and I cannot move ahead with the liquidation, with the winding up of the company, so please dissolve the company. Will the court come up and say yes, okay, I dissolve the company is declared to be dissolved, and the registrar, it strikes off the name from the register? No. Why will the court rely on the work of this liquidator? The court did not send this liquidator. This liquidator was sent by the creditors, appointed by the creditors, appointed by the members. Right? So now what will happen is that this liquidator will pass on all the final accounts and the statements to the official liquidator. Right? But do you think, will you allow that liquidator that okay, your work is done and go and submit it over there and get it dissolved? No. In between, you will want to inspect, you will want to see what proceedings have you conducted, what are the accounts, what are the dealings you have entered into. You will check it before it goes forward to the official liquidator. So for that purpose, the Act says, the section 509 says that the liquidator will have to lay down the final account. So for the past 3-4 years, the liquidator have been laying down the account for one specific year, one entire year, in the meeting of the members and the meeting of the creditors, right? Now it is his responsibility to correlate and consolidate all of these accounts, all of these statements, and then prepare one final consolidated account. When I say consolidated, that doesn't mean that I'm talking about the holding that you have been doing in your accountancy. No. Consolidated means that he is consolidating all the accounts of the 4 years, and then he prepares the final account to present it in the meeting of the members and the meeting of the creditors, right? And he'll be personally present over there to explain and to give reason if you have any query, if you have any doubt, right? And then when everything is prepared, he calls the meeting. But now how does he call a meeting? It's been 4 years, the directors have all left, they are busy in their life somewhere else. He cannot now issue a notice. He does not have money remaining, because if he had money, he would have paid off the creditors. Or if all the creditors are paid and still he had money, he would have given it back to the contributories. He has no money, right? So what does the liquidator do? The liquidator, for its administrative cost, had put aside a little amount of money, and with that little amount, what will he do is that he will give an advertisement in the official gazette and the newspaper in that district only, right? So whosoever who sees that notification in the official gazette or the advertisement in the newspaper can come for the meeting, right? That advertisement will lay down specifically what is the date, what is the time, and what is the place of the meeting of the member and the creditors separately. And in that meeting, he will lay down all the statements. He'll stand over there, he'll explain it to you, he'll give you all the accounts, he'll give you all the details. He will show you the clear picture of how the winding up had been conducted for the past 3-4 years, whatever he has taken, right? And once you are satisfied, he'll go ahead with the official liquidator. So is there any time limit prescribed for him? Yes. He will have to file this final account, the statements and everything with the official liquidator and the registrar within 1 week. 1 week from where? 1 week from the conclusion of the creditors meeting, because we know the creditors meeting is being conducted after we have held the general meeting of the members, right? So from the day the creditors meeting have been concluded, right, next 1 week is the time available for you. Within that 1 week, you will have to send this account and the statement to the official liquidator as well as to the registrar. You will have to file it with them, right? And when you're filing it, the liquidator and the registrar, they assume that yes, you have had held the meeting of the members and the creditors and they have seen it, and with that assumption they will take it ahead, right? They will not go ahead and discuss again, because they know that yeah, if it is coming from the liquidator, the meeting have been held and everybody is on the same parallel ground, right? But if there is a situation behind it that the meeting could not be held, what do you mean the meeting could not be held? Yes, the meeting would not be held because you have not issued the notice to each and every member and the creditor. What have you done is that you have given an advertisement in the official gazette and the local newspaper, not in the state, in just the local district. So there is a high probability that people do not see that advertisement, right? Because most of your members and creditors may be located outside your district, nationwide if it's a big company. So they never come to know, because nobody checks the official liquidator, official gazette practically every day, right? So how do they know that yeah, they have, how do you know that you are holding a meeting? So there can be a situation nobody turns up. You don't even, the members who have come, they don't even qualify the criteria for the quorum of the meeting, and so the meeting cannot be held. And if the meeting cannot be held, then how do you assume that the accounts and the statements have been approved by the members and the creditors? They have not been, right? So what to do in that case? Is it a serious issue? Should we now go ahead and again call the meeting and get it authorized? No. The liquidator says it's not a big deal. The liquidator that had been appointed by the creditors, he has done his task, and I will do the validity check. So even if the members, they come for the meeting, they have no right to do anything. What can they do? The winding up proceedings have been completed. But yeah, if they think that something has gone wrong, right, if some overriding preferential payments have been made, like other than secured creditors, somebody else have been made the payment, there have been preferences, or the liquidator has not performed the duty with his integrity or something, then the point can be raised. But even that things can be checked by the official liquidator, right? So even if the meeting was called and could not be held due to the absence of quorum, there is no issue with that. He will just have to state that yes, look at this, I had given the advertisement, everything was going very well, but since the quorum could not be met, the meeting could not be held. And then he would file it down to the liquidator and the registrar, right? So what will the registrar do then? When the registrar receives those accounts from the liquidator, he will go ahead and register them, that yes, this is the final account of the winding up and it has been registered, right? Now the official liquidator, on the other hand, registrar's work is done, and the official liquidator's action will come into play. So what will he do? He will come and he will inspect whether the winding up proceedings had been carried forward with integrity, it had been carried forward with due diligence, it had been carried forward the way it had to be, right? So he'll check whether whatever the act says, the list, the priority, the overriding preferential payment, the preferential payment, paying it off to the government, taxes and everything, and at last the creditors. Was that list or was that pattern or that hierarchy followed? Right? Did he make good attempts? Did he call for quotations and sell out the assets? Was the asset sold out for close to the fair value, close to the market value? So he will scrutinize everything. He'll take the accounts and then he'll see, okay, this is this. As per the market, okay, this was the rate. It's okay. So the official liquidator, basically he does the parity check, whether or not everything has been correct. Right? And then if he concludes that yes, the winding up proceedings have been carried forward very well, that means the assets have been disposed very properly, the cash that the company had, the cash that it gained by disposal of the assets, they have been utilized to make the payments for the for the liabilities, for the creditors, right? If they had like low funds with them, then they had also made the call for the shares on which the call money was pending. They have caught hold of the contributors who had debts due to the company and they have recovered the debts. So he'll check all these things, whether these procedures have been performed very well, and if they have been performed very well, he'll go to the court and he'll say that yes, everything is correct. And once the official liquidator says that everything is correct, the court on the very next moment orders the dissolution, and with that order the company stands dissolved, right? And that date would be court's order, right? But we'll assume that the court has given the order on the date of submission of the report, right? And what is the basic fundamental behind that report? That the dissolution, or sorry, the winding up affairs of the company, they have not been conducted in any manner which would be prejudicial either to the members, to the creditors, or which would be prejudicial to the public in general, right? So if they are not prejudicial to any of these parties, it is well. But on the other hand, if the liquidator feels that no, something is going wrong, then he would enter into the further investigation. But he cannot enter into the further investigation all by himself. What will he have to do is that he will have to go to the court and say that listen, the affairs of the winding up have not been conducted in a way which is not prejudicial to the members and the creditors, but it has been conducted in a way which is prejudicial for the interest of the members, the creditors, or the public, any one of them. And if the court now comes to know that yeah, it was prejudicially conducted, then the court may order that liquidator to go ahead with investigation, and will give all such powers to the liquidator as is necessary for that official liquidator to investigate, right? And then the official liquidator goes ahead, investigates into the matter, and then comes back with another report, right? And since all the powers have already been vested upon him, he can do nothing when he goes back, right? So this is the last time he went for the scrutiny. Now he has come back and now everything has to be concluded. So if now he finds that okay, everything was well, everything was conducted very well, or if there was something that was going wrong, it has been rectified and something, or the report can also say that no, there's a big issue. The winding up proceedings have not been conducted very well. It is prejudicial still to the interest of the members or the creditors or the public in general. So now the court will take appropriate action. Now the decision goes to the court. The court will see the intensity of the matter, the intensity of the issue, and then accordingly take further steps. That is none of our concern. Let it be with the court, that is case specific thing, right? So for us, this was the entire procedure that was given by the act, right? And if you remember, or if you try to link, then the last portion, section 509, where we talk about the dissolution of the company, then it is exactly the same that we talked about the dissolution in the members' voluntary winding up, with the only difference that the liquidator will have to call a separate meeting for the creditors, right? Otherwise, over here also the liquidator has all the power and everything to do, and again laying down those accounts, calling the official liquidator, investigation, registered by the registrar, and other steps. All these things are common, right? So that is all about the dissolution and all about the creditors voluntary winding up. So with this we come to the end of the topic of the creditors voluntary winding up, right? Now over here we'll conclude the lecture. In the next lecture, in the very next lecture, we will cover up the details about the committee of inspection under the creditors voluntary winding up, right, section 503, and then we will mark a line and draw the differences between the creditors voluntary winding up and the members voluntary winding up also in the next class, right? So please stay tuned for that lecture. That will be an important lecture for you, because over there you will get to know the difference, and that will clear all your concept about the members and the creditors voluntary winding up, right? So please stay tuned for that. Until then, this is Abhinay Gupta signing off. Thank you and bye bye.